Would you please start the screen sharing? Okay, let's start the wrap-up conclusion for this conference. Hello, all the participants and attendants. Hello is time neutral. And from Tokyo, good evening. In this session, concluding session, there is only one speaker. It is me. So I need to introduce myself. My name is Atsuko Kanehara, professor at Sophia University, president of the Japanese Society of International Law, and counselor of the Sasagawa Peace Foundation. It is really a great honor for me to conclude this so important conference running for 3 days. I would like to express my sincere gratitude to Japan Institute of International Affairs, Naval War College, Sasagawa Peace Foundation, World Maritime University, Japan Foundation, and all the organizers. Slide 2, please. It is not an easy task for me to conclude this conference. And particularly, I would like to focus on the manifold nature of the law of the sea. This is because this conference eloquently demonstrated that manifold nature. Furthermore, the manifold nature is even multi-layered. I would like to propose 3 layers that form the manifold nature of the law of the sea. I will conclude this conference by applying the 3 perspectives that represent the multi-layers one by one. Each perspective forms a set of terms that are in contrast to each other. They are, first, holistic but specific. Second, static but dynamic. And third, theoretical but practical. These 3 sets of terms reflect the multi-layers to construct the manifold nature of the law of the sea. I really hope these sets of terms will work as the perspectives to conclude this wonderful conference. Let me try. Please end the screen sharing. The first perspective is that the law of the sea is holistic but specific. How can we find in this conference the 2 factors that are in contrast to each other? It is not to mention that UNCLOS, a so-called the Constitution of Oceans, covers almost all the fields of public international law by its 17 parts and 320 articles. Regarding the contents of this conference, looking at the program, the themes of the 7 panels may seem at a glance specific. This is because the title of the conference is Spotlighting the East Asia and the Pacific region. But in many ways, actually, this conference demonstrated significantly its wide coverage. I will explain this by the following 4 points. First, under each theme of a panel, speakers richly enlarged and widened the discussion. For instance, panel 1 on baselines and archipelagic states touched upon not only these legal concepts, but also unilateral and the challenging ambition of widening jurisdictional sea areas based upon problematic use of archipelagic baselines. The panel also addressed to the issue of sea level rise. The panel 4 on East China Sea maritime boundaries analyzed this issue of maritime delimitation with deep consideration of dispute settlement too. Second, this conference dealt with the issues that UNCLOS treats relatively in a succinct manner. They are issues of maritime security and the Arctic. Panel 3 and Panel 4 of the conference took up these issues. The maritime security is becoming a keen issue for the law of the sea, and particularly to the East China Sea and the South China Sea. In this regard, Professor James Glasgow and the Naval War College took the initiative of this conference. Panel 4 examined the issue of navigation light and law enforcement. Each of it is doubtlessly a very important issue of the law of the sea. Law enforcement does not have clear definition under UNCLOS. In this regard, Panel 4 dealt with it in relation to navigation light. Such a viewpoint is really indispensable to the law of the sea and therefore very useful. Third, the panels of the conference did not take up, at least directly, some of the main parts of UNCLOS. They are issues of natural resources development and dispute settlement. These issues did not apparently form the themes of all the 7 panels of the conference. Nonetheless, we had an honor to have as keynote speakers and the moderator judges of ITROS, Judge Shunji Yanai, former Judge Rudiger Wolfram, and Judge Jin Hyun Paek, and Secretary General of the Seabed Authority, Mr. Michael Roach. Their keynote speeches and way of chairing the panel certainly added to this conference the viewpoint of dispute settlement and natural resources development. Fourth, the conference paid attention to the new issues that UNCLOS did not sufficiently know at its adoption in 1982. They are such as BBNJ, plastic litter, and global warming. In dealing with these issues, panelists enlarged their examination, not confining themselves to UNCLOS, but considering the relationship among the multiple legal regimes, namely the relationship between the law of the sea or UNCLOS on the one hand, and the treaties on environmental protection and WTO on the other hand. Really, by efficient interplays among the relevant international legal regimes, the law of the sea could contribute to achieving the goals of the conservation and sustainable use of BBNJ, combating global warming, and protection of marine environment from the harmful effects caused by plastic litter. This first element brings us to the second set of factors, providing the perspective for concluding this conference. It is static but dynamic. It is not to mention that the law of the sea is one of the oldest fields in international law, taking several centuries at least. Humankind established and further refined fundamental principles and concepts of the law of the sea. They still hold solid significance under UNCLOS that succeeded the 1958 four Geneva Conventions on the law of the sea. To understand this, it is enough for us to think the legal regimes of high seas and territorial seas and the concepts forming the essential elements of these legal regimes. They are, for instance, freedom of high seas, navigation right, innocent passage, territorial sovereignty. UNCLOS, in the latter half of the 20th century, introduced its complicated system of the distribution of jurisdiction to coastal states, flag states, port states, under the refined zone system of sea areas, such as territorial sea, contiguous zone, exclusive economic zone, archipelagic waters, continental shelf, and deep sea bed. In the long history of its development, the law of the sea has fostered and maintained its fundamental principles and concepts. This means the static aspect of the law of the sea and UNCLOS. We find some of the fundamental concepts of the law of the sea in the themes of the panels of this conference. They are such as baselines, archipelago, archipelagic baselines, navigation right, law enforcement, and maritime boundaries. The unchangeable significance of these concepts for the law of the sea eloquently proves the static nature of it. To respect the historical existence of the law of the sea, this conference had, as the moderator for Panel 1, Professor Masaharu Yanagihara, an expert of the history of international law. In comparison, the law of the sea is facing very radical and rapid changes due to the development of technology of marine uses and growing harmful impacts on oceans by such uses. The relatively new issues of the law of the sea are such as the Marine Environmental Protection, BBNJ, combating global warming in the concept of the law of the sea, particularly sea level rise, coping with the plastic litter. They could be included in the issues of the marine environmental protection under the Part 12 of UNCLOS. UNCLOS could cover these issues by interpretation and application of the relevant provisions, mainly under its Part 12. However, far beyond that, these issues may strongly require some amendment of UNCLOS and even creation of new rules of the law of the sea in order to most effectively tackle these newly emerging issues. Please allow me to add the issue of combating pandemic to the list of the new issues with which UNCLOS is facing serious challenges. Due to the COVID-19 pandemic, all the participants, attendants of this conference had difficulty to get together for the conference which was scheduled in 2020. Unfortunately, the harmful effects of the pandemics are still attacking our globe. For this reason, even this year, in 2021, we could not convene the conference in person. So everybody here would not deny the necessity of international law to effectively counter such devastating natural disaster. Certainly, this is the case with the law of the sea. As worldwide reported, the Diamond Princess anchored at the Yokohama port of Japan with the infected on board. In taking necessary measures to prevent further spread of the infection, Japan seriously considered that the relationship between the flag state jurisdiction and the port state jurisdiction in relation to foreign vessels existing at ports in internal waters. The experience of the COVID-19 pandemic has raised further difficult issues to be examined for the purpose of necessary amendment of the law of the sea and even possible creation of its new rules. These newly emerging issues could require changes of the key concepts and even the fundamental ideas of the law of the sea, such as distribution of jurisdiction to port states, coastal states, flag states, and even the solid zone system of sea areas. By flexibly responding to such changes, the law of the sea would really acquire a dynamic nature. Thus far, I explained the second set of factors that gives me one perspective to conclude this conference, namely static but dynamic. Then, how can the law of the sea keep its longevity by coping with the newly emerging issues? I think it is by holding practical attitudes that should necessarily accompany theoretical approaches. Here, we have come to the third set of factors that were in contrast to each other. Theoretical, but practical. Regarding the contents of this conference, it aimed at dealing with both law and policy, and it focused upon peaceful maritime engagement in East Asia and the Pacific region. Therefore, the law of the sea was discussed with particularly this regional concern of East Asia and the Pacific region. It undoubtedly gave us an indispensable practical attitude that should accompany the theoretical discussions on the issues of the law of the sea. Let me explain the achievement of conference in this regard in taking some examples. The East Asian countries have serious concern with China's unilateral and even aggressive ambition and conducts. Certainly, such concern is commonly shared by the South Asian countries. Panel 1, regarding archipelagic baselines, it gave thorough theoretical consideration of the interpretation of UNCLOS and possible existence of customary international law. Furthermore, it examined the illegal use of archipelagic baselines by China. This was really a practical examination keenly motivated not only by the South Asian countries, but also by East Asian countries as well. Panel 3 touched upon the issue of Arctic. In this panel, not only the voices of the coastal states of the Arctic, but also the viewpoints of non-coastal states were also heard enough for the purpose of building the Arctic regime. The voices of non-coastal states could add to the theoretical analysis of the possible Arctic regime the reflection of their practical desire. As non-coastal states of the Arctic, the East Asian countries are trying to become essential stakeholders, in some sense, in a competitive manner. Panel 6 and Panel 7 did not stop at theoretical evaluation of the relevant legal regimes for the themes of the panels. They also dealt with the impact of BBNJ on the region and the issue of the global warming, particularly by emphasizing the sea level rise. In this sense, these panels too never lost the practical viewpoints. Thus, these ways of examination on the issues under the panels undeniably prove the fine combination between theoretical and practical viewpoints of this conference. In addition, I would like to add the valuable participation to this conference from both academic and diplomatic societies. These speakers really embodied the theoretical and practical viewpoints in dealing with the themes of this conference. Thus far, I examined the manifold nature of the law of the sea. For doing so, I applied the three perspectives, namely the three sets of factors that are in contrast to each other. They are holistic but specific, static but dynamic, and theoretical but practical. This multilayer really constructs the manifold nature of the law of the sea. The contents and contributors of this conference impeccably represent this manifold nature of the law of the sea. Now, I am coming to the end of my conclusion and also the end of this important conference. On this occasion, I hope I am allowed to propose my humble thought on the law of the sea. I would like to emphasize the common nature of the law of the sea. From a time-oriented viewpoint, it is remarkable that this conference is the 44th conference on ocean law and policy. We had an honor to have superb introduction given by Professor Miron Nordqvist. He has continuously taken the leading role for the success of the conferences. The law of the sea needs to survive newly emerging challenges. For that goal, all of us gathering here have a heavy but a very honorable duty to inherit the traditional law of the sea, to collaborate for maintaining our maritime order. Beyond that, from now on, we need to collaborate for passing on the future generation the maritime order at our hand. From a space-oriented viewpoint, we should not forget that every maritime issue and its handling have both regional and global implication. We really know that the oceans cover our globe entirely. Many uses of oceans are taking place at the same time on the globe. One handling of a maritime issue in some region doubtlessly has impacts on other regions of the world. Taking seriously into consideration of these points, both from a time perspective and from a space perspective as well, we will never leave any states and anyone as bystanders to the maritime order. This is because all of us share the common maritime order, which means our common but manifold maritime order. Thank you.